Good morning. Welcome to Wealth Watch. Thanks again for joining us. Before we get going today, I did want to extend a thank you to our attendees. The response to our question and answer session 2 weeks ago was really striking. So we do appreciate all the questions and the back and forth. It's good to see the participation and to know that we're using this technology correctly to be able to connect with our clients out there. Little setup on today. For the past 2 months, we have directed the conversation primarily to our personal clients and how, as COVID-19 has changed and shaped the financial world, how that's impacted them. And today we're gonna shift gears a bit, and we're gonna talk about the institutional world and how that change in the financial marketplace is affecting businesses, is affecting the employee benefit plans they're putting out there, and then affecting those participating in those plans. So a little bit of a departure from an audience perspective. As you may recall, if you've been with us from the start, our very first webcast was devoted to the CARES Act and how it impacted required minimum distributions. Well, we're coming full circle today because we're going to talk about the CARES Act again. Only this time we're going to talk about how the CARES Act has impacted 401k plans. And joining us today is Jamie Eads. Jamie has spent 21 years in this industry working with employee benefit plans and companies. A lot of experience. He's got multiple accreditations from a lot of different firms dealing with different aspects of the plan. So Jamie, thanks for joining us this morning. Good morning. Jamie?
Yeah, good morning.
There.
Glad to be here.
So
Technology,
Jamie,
you gotta love it, right?
I know, right? So Jamie, as we kick off this morning, I think one of the things that would be helpful is if you could just set up for us just very generally what the CARES Act did as it relates to 401k plans.
Well, it was pretty sweeping, and it's a really fascinating piece of legislation in that, it was signed on March 27th, and 401k plans were expected to have everything implemented in 10 days. And normally when we have
that
a piece
just
of
does not
legislation
happen.
that they give us a year or 18 months. Yeah, so it was pretty sweeping. And I think, the intent that Congress had was to really lay out some relief for people. They knew that there was going to be a very high economic impact due to coronavirus. So they laid in some provisions, to try to help participants who were going to be struggling financially. And we can kind of get into the chapter and verse of what those provisions are and what they look like. But essentially, they said, hey, here's what we want all 401k plans to implement. And we're essentially going to give you a couple of years to make sure that your document matches these new, relief mechanisms that we've put into this law.
And so, as you just set up, they didn't give a very long runway for plan sponsors to be able to implement these things. What are some of the boxes that plan sponsors need to check? What do they need to do?
Well, essentially, the plan sponsors were only required to say, yes, we want to implement this, or no, we don't. And, just anecdotally, it looks like across the board, it's more than 90% of all plan sponsors said, yes, we want to put this into our plan. But the plan sponsors really didn't have to do anything other than say to their service providers, the record keepers, their administrators, yes, we want to do this, or no, we don't.
So then if we've got this broad sweeping legislation, all a plan sponsor has to do is say, yes, I want to do it, or no, I don't want to do it. How does that get captured long term? How is that reflected in the plan documentation that these changes have taken place?
Well, that's a really good point. I mean, when you have a lot of new rules in place, there's going to have to be, what we refer to in the business as a remedial amendment period. And the way Congress set this up was they actually said to plan sponsors, you have until December 31st, 2022. So almost a full 2-year period to get your plan documents amended to incorporate these provisions into the plan document. I think on the surface, some plan sponsors would say, well, I don't want to go through with that because that's a lot of work. But as a result of the Secure Act that was signed in December of 2019, all plans are going to have to do a document restatement in that time period anyway. So it's kind of like you get a 2-for-1 with your plan document restatements, and it'll be very similar to what sponsors saw, with EGTRA or, the HART Act or the Pension Protection Act or things like that. Their documents are going to have to be restated anyway.
So just to make sure I understand, and there's a good understanding out there, if let's say the CARES Act was a one-off event, just out there on its own, that would have likely generated a required restatement. But since another restatement was going to be required anyway, they're going to allow for both those things to be captured through one restatement. Is that what you're saying? Okay.
That is correct. So all of this will be rolled into the one restatement due to Secure Act from 2019.
Okay. So that sets up pretty well what's going on with plan sponsors. I think it sounds like it's a fairly hands-off process for them. So let's talk about the participants in 401k plans. What did the CARES Act do for them, and did it create anything that they need to do?
In terms of need to do, probably not, unless they're directly impacted by COVID-19. What the CARES Act spelled out, essentially, it's in my mind, it's twofold. So it created the ability for a participant to take a hardship withdrawal from their plan balance due to COVID-19 without paying the normal 10% penalty if they are under the age of 59 and a half. It is still a taxable hardship distribution. However, part of the CARES Act legislation was to allow folks to pay that tax liability over the next 2 years versus having to pay it all at once. So on the hardship side of things, it used to be that if you were requesting a financial hardship withdrawal, you had to provide documentation to your employer saying, here's what it's for. The CARES Act specifically said, if it's COVID-19 related, the plan sponsor can rely on participant certification, which is unheard of, literally in ERISA. But it's on the honor system, and they wanted to get this implemented quickly and worry about cleaning things up later. So just to make sure we're clear, you have to have been diagnosed or a spouse or dependent diagnosed with COVID-19 by a Center for Disease Control certified testing facility.
Okay.
Or you had to have direct financial hardship as a result of COVID-19, meaning you were furloughed, your place of employment closed down, your hours were reduced, you lost childcare due to COVID-19. But due to HIPAA and different, legislation that's out there, you can essentially just say, hey, I'm affected, and you're good to go.
So is it a fair statement, because obviously in the world of ERISA, it's rare that you can do things that don't need any documentation, don't need any sort of outsourced backup. Is it a fair statement to say that allowing for this basically honor system approach is in lockstep with, say, the PPP or the stimulus checks going out. This was get this money to these people who need it as fast as you possibly can.
Yeah, I mean, I think that was the intent there. And, again, this is, it's fascinating to me, being in the business for as long as I have been. I've never really seen anything that says we're going to work on the honor system. We don't, we're not going to ask any questions. But yes, the goal of that was to get relief to people as fast as humanly possible. The second part of CARES Act was essentially, if you met that criteria, you were directly affected. It essentially increased the amount you could borrow from your plan if your plan allowed for loans. It doubled that amount. You could borrow up to $100,000. If you had an existing loan in your plan allowed loans, and you were currently repaying that loan, it allowed you to say, hey, I want to stop those repayments, until the end of 2020. And they would essentially just move the entire amortization schedule over for you. Interest would still accrue and things like that. But they were really trying to get financial relief out there in these qualified plans, just super speedy.
And so I'm going to shift gears on you a little bit here, and let's now look at this from maybe the nefarious point of view. So I'm a participant. Maybe I'm in a plan that provides a lot of employer money that I immediately vest in. What is in place to prevent me from saying, oh, I have COVID-19, I've been diagnosed, I don't have to provide anyone with any backup documentation? How am I, one, protected from myself, and who's out there playing gatekeeper to make sure that there's no funny business going on with some of these money movements?
Yeah, I mean, that's a good question. And, I'll get my crystal ball out and say this. I don't know this. This is just something that I believe. I think if you go to your record keeper or your administrator and you take this money out saying, hey, I have COVID-19, I need this money, I think that likely puts you in a pool of people that may be audited by the IRS at some point. I don't know that, but I feel like when it's based on the honor system, the IRS can always come back to anybody and say, hey, I need you to prove what you've put on your tax return here. I'm not saying that will or won't happen, but what we've advised our plan sponsors is don't even get involved in the conversation, quite honestly. If a participant comes to you and says, hey, my wife or my husband has COVID-19, I need to get this money, we've directed our plan sponsors essentially have them call the service center directly. You don't want to get in the judgment process here, because the plan is held harmless. It's really on the participant to prove after the fact that they really did meet this criteria. Okay.
So you mentioned earlier these are broad sweeping provisions and with speed and backup that we've never seen before. Has there been any guidance put out yet as to how long these stay in place, or whether these become permanent, or what? How do we go forward from here? What's kind of the timeline on these specific provisions?
That's a good question as well. And, keeping with my crystal ball here in my lap, right now, the sunset is December 31st of this year, of 2020. Now, obviously, if nobody knows what's going to happen with this disease, if there's a second wave in the fall, as some of the scientists are predicting, I can foresee this being extended indefinitely. I can see them doing it, 1 year at a time. to say, okay, 2021, these provisions will be in place and they sunset at the end of 2021. We really just don't know. But my gut tells me that you will see an extension into next year, probably. But we don't know exactly when it will sunset, if at all.
Okay, Jamie, I'm going to back up for a second here. We do have a question, and it's fairly long, so I'm going to try to condense it here. But it in effect is asking, should plan sponsors remove themselves from the situation, even if they're acting in the participant's best interest? And so I assume that's related back to what you were just saying about if somebody's trying to make a COVID-19 either hardship withdrawal or some sort of loan extension, should plans, I think what they're saying is, should they advise their participant not to take it if they know that the participant probably is gaming the system or knows that that's not in their financial best interest?
Well, obviously I'm not a lawyer, so I'm not trying to give legal advice here. However, I will say this: there is a fine line between protecting someone from their self, and we play that role here at Wealth South quite a bit to say, do you really need to take a plan loan to buy a bass boat?
Right.
There's no prohibition against it, but is that the right thing for you to do? So what I would say to plan sponsors is, in this particular case, yes, remove yourself from the situation, simply because the plan is being held harmless by the IRS and the DOL, saying the participant says they're affected, therefore they are affected. I think it's a bad idea for somebody that maybe doesn't need it to be taking this money out and, going on vacation. I think that's crazy. That's my personal opinion. However, you can't really stop somebody from doing it. So in this particular instance, I would say yes, probably just
blanket statement, remove yourself from the situation.
I think so, yes.
Okay, well, as we kind of bring it to a close here, I think one thing that may be helpful as we talk about implementing these changes in plans, informing participants, et cetera, different management firms have kind of different ideas about how to communicate with their clients and how to help them implement this. Talk a little bit about how Wealth South has interacted with their client base to get these things off the ground.
So, again, this legislation was signed on March 27th, and we had this up and running, I want to say, on April 5th. So literally 10 days later. And essentially what we did is we said to our sponsors, unless you have a very good reason not to do this, just let it go into effect and we'll worry about the documents and the restatements later. We have to do it anyway due to the Secure Act. And we were doing some things firm-wide as it relates to the Secure Act, and we're hopeful to bring you, a Wealth Watch later in the year talking about some of the things that the Secure Act put into place and some opportunities for plans to, look at how their plan is operating. But, we essentially said, look, let's put these things in place and let's help those that need the help. So, and we're, of course, always available to answer questions for anybody. This is what we do. If your plan isn't necessarily operating the way you think it should be, or if your provider hasn't mentioned this stuff to you yet, they probably should have.
Very good. Very good. Well, any words of wisdom to leave the plan universe on as we wrap up here today?
I would say if you have questions, if you need help with something, we're always available. We're going to make sure that we have, kind of a one-sheeter or something out there that kind of distills all this down into a a bulleted list on our resources page over at wealthsouth.com. So visit us there. But if there's something that we can do to help, let us know. We're always glad to lend a hand and give you a second opinion on anything as it relates to your qualified plan.
Well, Jamie, thanks very much for the time this morning. Obviously very informative. And as Jamie mentioned, we'll have those provisions bulleted out for those of you attending today. If you reference back to your invitation, there is a link to that resource page embedded in the invitation, or just reach out to someone here at WellSouth, and we can certainly get you to that landing spot. So thanks for joining us. We'll be back in 2 weeks, June 24th at 10 a.m. Eastern time. So we look forward to seeing you then. And until then, stay safe and take care.